May it please the court. My name is Kaylin Johnson, and I represent the defendant, Sen Manufacturing Company, in this matter. We are here today because the plaintiff, Bryce Jennings, entered into a valid employment contract with the Sen Manufacturing Company on April 1st, 2016. The plaintiff was hired as the district manager in southern Minnesota and North Dakota. The plaintiff had an opportunity to review the contract and signed his name at the bottom on April 1st. In that contract, there is an arbitral clause. Within that clause, it states that if parties are not able to resolve their dispute, they are to participate in arbitration. The arbitral clause is valid and follows that parties participate in arbitration to settle their dispute. Under U.S. law, the federal court is to review the arbitral clause and compel arbitration if it finds the clause valid. The role of the court should be limited to reviewing the arbitral clause and not the entire contract. The arbitral clause in the contract is valid. It's a valid arbitration agreement. In order for arbitration to exist, the parties must agree to arbitrate. They must agree to have a third party neutral decide the dispute, and the agreement is final and binding. Here, both parties signed a contract with the arbitral clause agreeing to arbitrate future disputes. The arbitral clause itself contains provisions that one arbitrator will decide the case, and it will be both final and binding. This meets the necessary elements of arbitration, and therefore the parties should participate in arbitration as stated in the agreement. Under the doctrine of separability, the arbitral clause is upheld separately from any disputes in the contract itself. This doctrine establishes that unless a party specifically challenges the arbitration clause itself, as opposed to the container contract, the arbitrator should have the first opportunity to consider arbitrability. In other words, it makes the arbitral clause legally and analytically separate of any container contract. Under Prima Paint versus Conklin Manufacturing Company, the federal court is instructed to order arbitration to proceed once it is satisfied that the making of the agreement for the arbitration or the failure to comply is not an issue. Here, the plaintiff does not dispute the arbitration agreement. Although he makes claims about wrongful termination and assault, this is completely independent of the arbitration agreement. Consistent with Prima Paint, it follows that the federal court order arbitration upon agreement that the arbitral clause itself is not in dispute. Therefore, this should be compelled to arbitration. In addition, this arbitral clause supports grounds for arbitrability. Under first options of Chicago Inc. versus Kaplan, unless the parties have a clear and unmistakable evidence that they agreed to have an arbitrator decide arbitrability, the court is to decide. The court then has the power to find the arbitral clause valid and compel the arbitration. Arbitrability defines which disputes can be lawfully submitted to arbitration. This means that the arbitral clause must clearly define the issues which will be decided for an arbitration. Here, the arbitral clause specifically states any claim for money damages relating to employment with the company, which involves the company or its affiliates, shall be settled by final and binding arbitration administered by the American Arbitration Association. One argument that the plaintiff makes is for wrongful termination. In a typical wrongful termination claim, the plaintiff will request money damages as a result of the termination. This is within the arbitral clause and should be compelled to arbitration. In addition, there is arbitrability because the plaintiff signed the contract agreeing to arbitration with a clear mind. The plaintiff had an opportunity to walk through the contract and with the employer and on his own. At no time did the plaintiff coerced into signing the contract or showed signs of unconscionability. The plaintiff signed the contract with a clear mind and should therefore abide by the agreement to arbitrate the disputes. Further, there is arbitrability because it has satisfied all the procedural conditions laid out in the contract. The arbitral clause specifically states that the parties shall try to resolve any disputes they may have. If the parties are unable to do so, then the parties will arbitrate except to the extent that they, 1, agree in writing to the contrary, 2, the law requires otherwise, And or 3, the law preserves the employee's rights notwithstanding the application of the principles. The parties were unable to resolve their dispute in this case. The parties did not agree to an alternative method of dispute resolution in writing. There is no law that the parties to resolve the dispute through a different method. And finally, there is no evidence that the law preserves the plaintiff's rights notwithstanding the application of the principles. All preconditions and exceptions have been addressed in the arbitral clause. None of the exceptions are justified, and it follows that this case should be compelled to arbitration. In this case, the arbitral clause is treated separately from the contract itself. It is supported by arbitrability because the clause lays out the scope of the disputes to be arbitrated. It is signed by the parties with a clear mind, and all preconditions for the clause are met. Therefore, we respectfully request that you compel the plaintiff's participation in arbitration. Thank you.